Good day, everyone. Eric Olsen from Helps. Welcome to Helps YouTube Live on April Fool's Day, April 1st, 2025. I'm not going to do any April Fools. But good to have you here. Hope the voice is better today. I did have a new mic, and I think it may have been in the wrong spot. So tell me if you hear it clearer. Hopefully it does. Good. That's good to hear. Okay. I moved it a little bit and checked. Well, I talked to our tech guy, Derek, and he got it straightened out. And he said, I need to put it closer to me. So good to have you. So my name's Eric, founder of Helps. Helps is a national law firm that represents seniors and disabled who owe debt they can't afford to pay. We represent people under the Fair Debt Collection Practices Act, so debt collectors have to leave them alone. And our important message to seniors and disabled persons is that your Social Security, your pension, your disability, your VA benefits are protected by federal law. Can't be taken from you. It's available for your needs, for your food, for your medicine. Even if someone were to sue you, they can't take this money. Twice the amount of your federal benefits is protected automatically in your bank account, regardless of what other funds are in there, by your bank without you having to do anything. If you happen to have more than that in there, the excess is also protected, just not automatically. You have to file a challenge to garnishment or claim exemption, but as long as you keep the balance less than twice the amount of your federal benefit like Social Security, then no one can take it. Okay? So that's what we do. And what we do is, our second mission, other than protecting seniors from collectors harassing them, is to educate seniors how they can maintain their financial independence. And that's why we have these YouTube live videos. So if you have any questions, you can put them in the chat feature. You can also look at some of our older episodes. We talk about things, new things all the time, and we repeat things all the time too, because we have a lot of new people, listen to this channel. I noticed someone had written in on a note, and they said something like, I need to speak to someone, even if they just listen. And so I know what that's like. I've represented tens of thousands of people with financial problems over the last 4 decades, over 4 decades. And so I talk to a lot of people. When people call Helps, a lot of times we'll say, I can ask a few questions. I can answer a few questions if I just can ask a few. Okay? And so, when we start out, we like to ask some basic questions. Your name, if you're married, where you live, what state. That can be important because state law is different. And what your age is, because a problem for someone in their 60s could be totally different than a problem with someone in their 80s. Okay? Has anyone sued you? Okay, we need to know about that. Are you buying a home or renting? If you're buying a home, how much you owe on the home, how much is it worth? If you're renting, what are you paying for rent? If you're buying a car, if you own a car, what you owe on the car, your make and model. So we ask a number of those types of questions so that we can, tell you what your rights are, and we listen to you too. What you're concerned about, but we do need to ask some basic questions to be able to help people. Okay. If you have some questions, you can put them in the chat feature. I'll address them there. Otherwise, I have things to talk about that people have inquired about. Recently, I had a debt collector tell me, as of COVID, it is legal to garnish Social Security. And no, total, complete lie. I don't think that was a legitimate debt collector. If it was, they broke the law. No. Your Social Security is protected. All forms of Social Security is protected. And it's protected in your bank account. Realize debt collectors, they're in the business to collect money, and so they don't necessarily have an incentive to tell you the truth that your income is protected and you don't need to pay this debt. About the only thing they're required to tell you is that they're a debt collector. Any information they get can be used for that purpose. They don't have to tell you your income's protected or your legal rights. But here at Helps, we're here to tell you what your legal rights are. Okay? And so listen to what we talk about. Every state has exemption laws that protect equity and property. but it's simply not the practice of consumer judgment creditors to try to go after a person's property, which means equity in a home, equity in a car, or equity in other property over and above what the exemption is for that state. They simply don't do it for a lot of different reasons. Okay? So this person contacted us from Louisiana and said, once I pay my bill, I don't have enough money left to pay for food. Most of my bills are on extensions. I pay a debt relief program, $256 a month to help with my credit card bills. I still have bills they do not cover for another $157 that I have to pay. I put out $413 a month on credit card bills. Each month I will soon have to sell my home. I cannot continue like this. Please call me. And we will call this person if we haven't already. So what's the deal here? Okay, I'm assuming they're on Social Security or a pension. They live in Louisiana. It doesn't matter where they live. But they're paying a debt relief program, $256 a month. And if you've been listening to me at all, you'll know what I'm going to say next. You know, if you enrolled in a debt management program or debt settlement program, did they tell you when you enrolled, you know, by the way, you don't need our help because all your income is protected. No one can touch your Social Security. The answer is going to be no, they never told you that. The reason they didn't tell you that, if they told you that, you would know you wouldn't need their help. And you wouldn't enroll with them, and therefore they wouldn't make money off of you. So, with rare exceptions, debt management companies don't tell seniors the complete truth, the fact that their income is protected. But you're going to hear it here from me. And if you're enrolled in a debt management company and you're going without food or medicine or heat or basic needs to be able to pay that, you could stop paying that debt management company. You can cancel with them. Okay? And ask them to return any money they're holding for you. And if you want our help, you can enroll in HELPS. What we'll do is you'll give us the creditors you owe money to. We're going to send them a cease and desist letter. They're going to leave you alone. Okay? Then he goes on to say, you know, so he's paying a debt management company, plus he's paying some other bills on his own, and then he's running up some more credit cards. So it's just kind of like he's spiraling down. You might have to... You know, if you didn't have to pay the debt management company, if you didn't have to pay these credit cards, maybe you could afford the house payment and keep the home. Okay? You know, HELPS can't put more money in your pocket, but what we can do is tell you where you don't need to spend your money so that you've got what money you do have available. Okay? Will I get a notice when you send a letter to the creditor? Yeah, you will. Our goal is to try to send those within 24 hours. All we need is the name, address, and account number. We don't need the balance. And if you don't have the address, we do have a master address, but it's always nice to have an address. And you will get a copy. We'll email you a copy of the letter that we sent. Michelle says, I was sued. I filed an answer telling them I am on Social Security and able to pay the debt. They filed a motion for a judgment on the pleadings, and judge ordered a pretrial conference to hear the motion. So, I'll explain this to you, Michelle. You really don't need to file an answer if you owe the debt, and you don't. You can file an answer to contest the debt if you have a reason why you don't owe it. Remember, your income is protected. Your Social Security is protected. If they get a judgment, they can't collect from you. You're judgment proof. Twice the money of your federal benefits in your bank account is protected as long as you keep the bank account balance less than twice the amount of your Social Security. No one can garnish your bank account. And again, if you had more than that in there, if it came from a retirement or Social Security, you could file a challenge to garnishment or claim of exemption with the court, and they would order that money be released. Okay, so your income's protected. Now, when you filed that answer, all you did is told the judge that you're on Social Security. That doesn't prevent them from still getting a judgment. A judgment is just an order saying that you owe the money. It doesn't mean that you have to pay it. Okay, it's just an order that you have that you owe the money. It doesn't mean, once again, it doesn't mean you have to pay it. And so when you file the answer, the judge, they try to bend over backwards to try to protect people's rights. So they just sent it for a pre-trial judgment. That's the end of it. Don't need to worry. Okay? In some states, after there's a judgment, a creditor might engage in some post-trial judgment proceedings, which means they may send you a form to fill out or ask you to answer some questions, usually in writing. Not always. Not every state does this. Florida, for example, has what's called a financial information sheet or fact information sheet that they'll send. And it can be intimidating to someone in Florida if they get a judgment against them and they see that, multiple pages asking a bunch of questions. 9/10 of them don't even apply to you. One of them asks about your kids' names and addresses and phone numbers, which I tell people, ignore it. They have no right to know that. But, and the other states have proceedings too. When that happens with the helps clients, if they're sued, we'll talk to them, tell them what the client needs to do. Sometimes I think these creditors that have judgments, they send these papers hoping that the person that they got the judgment against, the senior, for example, will call them on the phone and make arrangements to make payments. And remember, the creditor doesn't have to tell you that your income is protected. They don't have to give you that information, and they're not going to do it. They just want you to pay the debt, which you don't have to do if you're a senior and getting protected income. Okay. So Mary asks, what questions do they ask at a challenge to garnishment exemption? I have one coming up soon by telephone. Well, you can always call us and we'll go over that with you. And the only reason you have a challenge to garnishment or claim of exemption hearing is if they actually took money from your bank account and they're holding it. Remember, if they file a writ of if they get a judgment and they file a writ of garnishment, they have to file a writ of garnishment on your bank, okay? And if the amount in there is less than twice the amount you get in Social Security or other federal benefits, then your bank's going to protect that automatically. They're not going to take it out, and you don't need to file challenge to garnishment or claim exemption. You only need to file that if they're holding money for you, okay? So if you filed that, the court might set it for a hearing, but when they didn't take any money from you, it's kind of like, no, you don't need to worry about that. It's kind of a waste of everyone's time for there to be a hearing. Court would probably get you on the phone and they'd say, well, why'd you ask for this hearing? They didn't take any of your money. So no, you don't need to do that. What would you tell them? Usually you give some proof in writing that the money in the account, the excess money, came from Social Security. For example, you could send them last 3 or 4 months bank statements showing that your only income is Social Security and a pension. So the judge is going to want some proof that the excess money came from a protected source. That's all. Okay? But not to worry. Okay? So this person contacts us from Arkansas. Need your advice. Should or shouldn't file for bankruptcy and just stop paying the credit card companies? I am 65 on disability. Thank you. Well, HELPS was started because the vast majority of seniors that we dealt with when I was filing bankruptcy had no need to file bankruptcy. I probably filed between 30 to 40,000 bankruptcies over 3 decades. And HELPS was started because seniors would come in and I'd tell them, you don't need to file bankruptcy, but I know when I sent them home, creditors were going to call them and make their lives miserable. Now, why didn't they need to file bankruptcy? Well, because all their income was protected, no one could take it, and their assets were safe. So they had no need to file bankruptcy, but creditors could still sue them and call them on the phone, which could make things difficult. And so HELPS was started so that we could represent seniors to get debt collector communication. When when people enroll in helps, they give us the creditors to whom they owe money and the debt collectors, and we send out what's called a cease and desist letter. In 1974, a law was passed called the Fair Debt Collection Practices Act that provides that, that was in 1978, provides that if you're represented by an attorney, then debt collectors can no longer call or send demand letters anymore. And so that's what we do. When people enroll in helps, we send a cease and desist letter. They have to leave you alone. So are you going to have to file bankruptcy? Probably not. We'll talk to you about that. And you can always stop paying the credit card debt. You don't have to stop. You don't have to wait to enroll in helps or file bankruptcy to start paying credit cards. You can stop paying them now. Okay? If your income, you're 65, you're on disability, your income's protected, no, you don't need to worry. Robert asked, could the present administration change the rules regarding the protection of Social Security from garnishment? No. These laws were passed by Congress, and they've been in effect for decades. Social Security's been in effect since its inception. There will never be a law that will ever change the fact that your Social Security is protected from debt collectors. That's enshrined in stone. That's not going anywhere. Okay? Same thing that protects your pension and your disability and your VA benefits. You know, your pensions are protected under a federal law called ERISA, passed in 1974. And if your pension isn't protected under ERISA, I can assure you there's a state law that protects your pension. The same for disability income, VA benefits. So, no, there's no law there's nothing in the works that would indicate that any of these protections are ever going to be changed. Okay. They're holding my workers' comp husband's death compensation benefit where he was killed on the job. Now, you can call and talk to us, but workers' comp I'm sure it's protected in every state, okay? So, there are some benefits that are a little bit out of the ordinary. That would be one of them, but I'm sure there's a state law that will protect that, okay? Now, if they filed a garnishment and some of that cash was held up, you would have to file, once again, a challenge to garnish or claim exemption and present the law to the judge, although the judge could look it up himself pretty easily, and he would know that money is going to be protected. But you can talk to us, okay? And we'll talk to you about that, okay? If a lawsuit is filed, does the court have to eventually decide what to do with it if the plaintiff never is, if the defendant is never served? So it just, they're open forever? Well, okay, it depends on the state. A lot of states have state laws that says if a creditor were to sue you, they have so many days to get you served. It could be 90 days, it could be 6 months, it could be 60. It depends on the state. And if they don't serve you within that time, then the court could, simply dismiss the case. They would dismiss it without prejudice, meaning that the plaintiff, person who you owe money to, could sue you again if they wanted to. Now, why would they dismiss the case? Well, they don't want these cases sitting out there on their docket forever. Now, some states may let it sit there forever, but most have a timeline to get the paperwork served. And if they don't serve it within time, they're going to dismiss it. Okay? Kristen Olsen is not my daughter. Okay? We're not related, but she was the very first law clerk that I ever hired when I was an attorney. And I think I hired her back in, I can't remember, 1986, 85, somewhere around in there. She was a law student, and I hired her, and then she left my employment, went out on her own, and then did bankruptcy after I taught her how to do bankruptcy. And then, 4 or 5 or 6 years ago, she happened to come to a conference in my office, and I talked to Kristen about helps and asked her to come to work for helps, and she did. Okay? So she's not my daughter. So T-Bone asks, Eric, I received 3 lawsuits and have multiple debt collections. I'm 63 and I'm retired. Is 63 considered a senior? Also, if I get liens placed on my home, do those liens have to be paid? Okay, we'll talk about that for a second. Okay, the laws that we talk about here, it helps, really don't have a whole lot to do with age. They have to do with your income. Okay, if your income is Social Security or pension or disability or VA benefits, regardless of how old you are, that money is protected. Now, HELP stands for Help Eliminate Legal Problems for Seniors and Disabled. So we represent a lot of people that are, maybe under 62 and they're or in their 50s or 40s or whatever. It doesn't really matter how old you are. We talk about seniors a lot because the vast majority of our clients are seniors. Okay. So if they sue you, can there be a lien placed on your home? Yeah, normally there would be. A lien could be placed on the home on a home in the county where the judgment is located. Okay, and it depends on state law. In some states, a lien doesn't attach to the home. If, for example, in California, if homesteaded the property, there's no lien. In other states, if there's a judgment lien, if you go to sell the home, it can be removed. Okay, and in some states, it can be removed if there's if you're going to sell the home and it's going to sell for less than what the exemption is for that state where you live. Okay. In some states, if the equity is under a certain amount, the lien can be removed by filing bankruptcy. Okay. It depends on state law. So, do those liens have to be paid? Normally, they don't have to be paid now. Possibly it could be paid sometime at the future. Let's say, for example, you own the home with your wife, and you own it as joint tenants or tenants by entirety, which means that if you passed away before your wife, then at your death, the home would automatically go to your wife. The judgment was against you. When you die, the judgment lien disappears because you no longer own the property. Okay? Property automatically goes to your spouse. Or if you had a child's name on the property before there was a judgment, and then you pass away, then the property would go to your child, and the judgment lien disappears. So it doesn't mean it has to be paid. A lot of times it could be paid, either at your death from your estate, or if you go to sell the home, a lien could be removed. There's a lot of reasons why it doesn't have to be paid. Okay, when I mean have to be paid, does it have to be paid now? No. It's not the practice of consumer judgment creditors who get judgments, even if they have a lien that's in effect on your home and you have equity over the homestead exemption. They don't foreclose on people's homes for a number of reasons, so you shouldn't have an issue with that. And we can talk to you about that. Okay. In order to save money, my insurance agent suggested canceling my homeowner's policy insurance to pay on property taxes. I mean, you could technically do that if you own the home free and clear and you don't owe any money on it. Sure. There's a little bit of risk involved, but if it means keeping the home or not, then yeah, you could cancel the insurance, have that money be able to pay the property taxes. What's going to happen? I mean, the worst thing that would probably happen, your house is going to burn down, but what's the odds of that happening? Fairly remote. And if you can't pay it, you simply can't pay it. It's really easy for someone to say, well, you have to do this or you have to do that. Well, some people will say, well, if you get sued, you have to get an attorney, or you have to do this thing or that. You have to pay this debt or that. Well, that's easy to say if you have money to do it, but if you don't have money to do it, then that becomes different conversation then. If you don't have the money, and you don't need to do it, then maybe, you just don't do it. You don't have to do it. Sometimes people will give advice telling people, well, you have to do this, that, or another thing. They don't take into consideration the fact that the senior may not have enough money to do that thing that you're telling them they have to do. So, yeah, not keeping house insurance if you don't have the money. Now, you're not going to be able to do that if you've got a loan. The lender's going to require that, and if you canceled your insurance, they're going to put forced place insurance on there, and that's going to be more expensive. And the problem with forced placed insurance is that if you had an accident, or if your home, a tragedy on your home, then they only pay enough money to pay off the loan. They don't pay you any extra for any equity you have over and above what you owe on the loan. Plus, the insurance rates are a lot higher on forced place insurance. Okay? Okay, this person contacts us from Texas. And I have a credit card and consolidated loan that I can't afford to pay anymore. I'm not working and only receive about, it says $1,050 in Social Security. I need help to eliminate these accounts. Both accounts are with Discover. The loan is about $10,000. When I got the loan, I was working, but my job was eliminated and at that time I was earning approximately $40,000 a year, plus my Social Security. I'm 69 years old and have been having health issues. I did try to get another job, but due to my medical condition, I haven't been able to work. Excuse me. I saw a video that referred me to your organization. Please let me know what I need to know. I appreciate your support and assistance with my situation. Well, okay, let's talk about this. The only income this guy gets is a little bit over $1,000 in Social Security. And he owes debt to Discover. Doesn't have to pay it. His Social Security is protected. He can stop paying Discover, stop paying the credit card and the consolidated loan. He's going to have that money to use for his food and medicine and needs. If he enrolls in HELPS, we're going to send a letter to those two debt collectors or creditors, letting him know that he can't afford to pay him anymore, and they're going to leave him alone. That's what he does. And he could stop paying it immediately. He doesn't have to wait to enroll with HELPS. When people call us, a lot of times sometimes they'll ask, do I have to be behind before I get your help? No. If we have 5 people call us, one might be being sued, 3 or 4 out of the 5 are being called and creditors are harassing him, and 1 out of 5 is completely current on everything. They finally realize they can't keep up with the payments anymore. It doesn't matter where you are. So you can stop paying it. Okay. This person from Texas contacted us. I'm on the verge of filing bankruptcy in the next couple of days. I am disabled and widowed and will be 70 in November. As of right now, I am on SSI until my husband passed away in 2021, and then I received his Social Security disability benefits. Well, you don't need to file bankruptcy if your only income is Social Security. Is protected. I mean, you can if you want, but bankruptcy is not cheap. And I mean, the creditors can't do any. They can't touch your Social Security disability, or your Social Security. Can't touch. It's completely protected. That's our message to seniors. You enroll, you give us the creditors you owe money to. We're going to send them a cease and desist letter, and they're going to leave you alone. Okay? So this person writes us in. They say, after losing over half my income in my school district job due to cancer, I went from 820 credit score to into the toilet. Credit scores needing to use my credit cards. which at the time had zero balances. Now I had to make arrangements with my credit card companies and still cannot make ends meet. I'm appealing to you for help or direction in this matter. Thank you in advance. Please advise. So I'm assuming you're not working and you're getting some type of disability or Social Security. You've got cancer, can't work. You don't need to pay the credit cards. You can stop paying them. You can use your whatever income you have for your medical costs and for your food and your medicine and your needs. You can stop paying it. If creditors are bothering you, you can enroll in helps. We're going to send them a cease and desist letter, and they're going to leave you alone. And we're going to help you no matter what. You know, at least 1 out of 6, 1 out of 5, 1 out of 6, 1 out of 7 of our clients get our helps for free. Those that pay a very minimal amount to enroll in helps. We make it affordable for people. We don't want anyone being harassed. That's what we do. And that's our main mission, is to stop debt collectors from harassing you. And then our second mission is to educate you how you can maintain your financial independence. And that's why we have these YouTube live sessions, so that we can answer your questions. Okay? So this person contacted us some time back. And this is the notes from the paralegal when talked to her. It says, this person's considering filing bankruptcy. Explain why that may not be the next best option. They're in a sketchy rent-to-own situation. So in other words, they're buying a home, but it's not a land sale contract. It's a rent-to-own. We've never talked about that. Okay. There wouldn't be a problem with keeping that rent-to-own contract, assuming that it's valid. They called back and asked, is there a limit to how many creditors they could send in to us? Okay. They must have a lot. And the answer the paralegal put down was nope, with an exclamation part. And then the next question is, do we start working after the first payment? No. The paralegal wrote in. From the get-go. First month is free as a courtesy. Quoted the fees, read what we did, and the person enrolled. Actually, we read what we did, quoted the fees, and then enrolled. So it doesn't matter how many creditors you have. We don't even ask how many creditors you have. We ask how much you owe in debt. You know, we want to know, if a person only owed $500, they probably don't need help, or $1,000. Okay, but if you owe more than that, it's nice to have an idea of what you owe in debt. Now, if you owe $20,000 or $30,000, but if you told us you owed $400,000 or $500,000 or $500,000, we'd probably want to ask you a few more questions. But we'd never ask you how many different creditors do you have. Okay. At least not on the initial consultation. It doesn't have any effect on what you would pay helps to have us represent you, so you don't have to hear from those creditors. And the other thing we tell you, if you have a new creditor contact you, if you forget one, you can always call that in and give it to us. We need the name, address, and account number, and we're going to send them a cease and desist letter so they leave you alone. And if you incur a new debt after you're enrolled in helps for whatever reason, you let us know. We'll send a new cease and desist letter out to that new debt collector. So we represent you ongoing. And the most important thing is, if you ever have a question, you call us on the phone. We don't want you worrying. So the next thing they said here, do we start working after the first payment? No. When we enroll people, we keep you on the phone, and we'll ask, like, you get an email while we're talking on the phone, and everyone will say yes, and they'll say, sometimes, well, I'll get it on my phone, or get it on a computer. We'll turn your computer on, and then when we enroll you, we click a button, and our system will automatically send you an email that says, welcome to helps. And it has all our contact information, address, phone number, email address, and gives instructions how to get us the collectors you want to hear from. You can email them, fax them, text them, mail them to us, however you want to get them to us. And if you're particularly a little old sweet widow in her later 80s and you have difficulty with the internet, we'll take them over the phone. Okay, we just want to help you. Okay, and it's always the first 30 days free, at least the first 30 days free. It depends on when you get paid. So it's anywhere from 30 to 60 days the payment would begin. But you're enrolled immediately. When we send that email, or when we send that email to you confirming you're a client of Helps, you're a client right then. So if we hang up the phone with you, if you got a call in the next minute and you said, I'm represented by Helps, don't call me anymore, you give them our name and number. And if they call us, then you're going to be on our system as being our client. We're going to tell them, yeah, we represent this person. We're sending you out a cease and desist letter. Don't call them anymore. Leave them alone. Okay? That's how it works. Kathy writes in, I just sent another settlement offer from my nightmare debt people. They are not debt collecting company. It's the actual company that I owe. So a call to be sure Helps got the email. Yeah, if it's an original creditor, in most states, they can still send you correspondence. We'll still send them a cease and desist letter, and they normally stop calling you, but a lot of times they would still send you a bill. If you don't want to get the bill, you can do a change of address so the bill goes to your name, care of Helps with our address. And you can do that either on a paper copy of the bill you get, or you can do it online. You can have it change the email address to go to Helps. They sent you a settlement offer. You can disregard that. Okay? Here's a good example. Sorry about that. So this person, they started contacting us, it looks like last fall. Well, actually 2 years ago. This is a good example of what we do. When someone contacts us, so we try to reach back to you. Okay, we'll try to call you back. So on August 5th, 2023, one of our paralegal called, no voicemail, said the wireless customer not available, try later. 2 days later, we called again. Same thing. 2 days later, a week later, we called again. Something I just happened to bounce out of our system here. Hold on. Sorry about that. So the person called again, and if I remember right, the ending on this is going to be, now I'm going to guess if it's the right ending. Now a couple days ago, they called again, and they told us they were with a debt management company, and they had been sued 3 times, and they called Helps and enrolled with Helps. Pretty sure that's what it's going to say. So that was back in 2023 when they originally contacted us. Then they called us on March 11th. They signed up with National Debt Relief, and they have been taking $400 a month from her ever since. And now she's been sued 3 times. And they got tired of being sued, and they enrolled with Helps. Yeah, if you're with a debt management company, you can't afford them, you can quit. Give them, enroll with helps. We're going to send a letter to the creditors. They're going to leave you alone. We don't want you to worry about them. So, this person calls us from North Carolina. They get Social Security and VA benefits. And the paralegal says this person has bills climbing her back. She is a veteran with lots of debt. She tried to take classes and now she is being billed for tuition for a class she never took. She sells some stuff on the side. And she has multiple timeshares. And her husband passed away. So we enrolled this person and they're going to be just fine. Okay? Then get rid of those timeshares. If you got a timeshare, you don't have to pay it anymore. You can drop paying it. Stop paying it. They're not going to sue you. They don't sue. It wouldn't matter if they did sue. They can't collect from you. It's not the practice of timeshares to sue. Just so you know that. They threaten, but that's about it. So this person contacts us and they say, hello, my name is, and I need some advice on help with debt. I'm retired and since fell into bad health. I used up all my savings and now I am at wit's end. I need to speak to someone, even if they listen. That's where I got the topic for today. We listen. So we called the person back. And they live in South Carolina. He had a business, he got sick, and now he's desperately underwater. And we enrolled him. But it kind of, he emails us, and he's in this desperate situation, and he doesn't know if we can help him, and he says, if anything, if you can just listen to me, okay? And so that kind of registered to me. And yeah, we will listen to you. If you call and you have a question or a debt problem, yeah, we'll listen to you, okay? But we're not only going to listen, we're going to tell you what your rights are and why you don't need to worry. And we're going to tell you that you can always call us if you have a problem or if you're scared or worried. Does forgiven debt have to be reported to the IRS? Well, we talk about that a lot. Creditors, if they deem the debt isn't collectible, technically they're required to send the IRS a form called a 1099-C, which tells the IRS that this creditor to whom you owe money hasn't been able to collect the debt, and therefore the IRS should consider this income to you. Now, the question you've got, Yin Yang, is, are you going to have to pay taxes on that? No. Highly, highly unlikely. You've got to realize the people that helps works with are the half of seniors that have incomes within 200% of the poverty line, or they have modest incomes, even more than that, okay? There's a form you can file, 982, if you're required to file taxes, you can file Form 982, and if your debts exceed your assets, then you're insolvent and there's no tax. But if you're not required to file tax returns and you get a 1099-C, you don't need to file tax return. You just forget about the tax, the 1099-C. The IRS isn't going to do anything. They don't do that. It's more paperwork for them. They know from what your income is that if you ended up owing taxes, you could get on currently not collectible status and not have to pay the tax. So the chances of you having to pay taxes on that debt yin yang is so close to zero, it's not even worth mentioning. Yeah. And we have videos that talk about that. So this person contacts us from Arizona. Well, actually from Texas. They get a pension and wages. And then they have a home that's free and clear. So they live in Texas. Texas has pretty good creditor protections. They'll protect virtually an unlimited amount of equity you have in a home. Unless you have, if it's over so many acres, then there could be a problem. But if it's a home on a lot, no, it's protected. And they don't allow garnishment of wages. Okay? Now, so they're asking, receiving a slew of solicitations from attorneys suddenly and has given up on trying to maintain credit card debt. She is ready for help, has not been served, and discussed the lawsuit process. So, why is she getting a slew of solicitations from attorneys? Well, some bankruptcy attorneys ascribe to services that lets them know if someone's been sued in the area where they practice, and they'll send an advertisement letter saying, contact us and we can file bankruptcy for you. Okay. Years ago, attorneys weren't allowed to solicit, but the laws changed. They advertise a lot. Okay. When there used to be phone books, they used to advertise in the phone books. Thousands and thousands of dollars. But now phone books have gone by the wayside. They're kind of a history. So where do attorneys advertise? Well, they advertise on the internet. They might get AdWords, or they have fancy websites. And then another way bankruptcy attorneys advertise is by subscribing to a service and sending out these letters telling people, hey, it looks like you've been sued. And sometimes our clients call us and say, I'm getting these advertising letters. And we say, well, you've been sued. And they say, well, I don't even know anything about it. Yeah, it's not uncommon for you to get the letter even before you've been sued. But you're not going to need to worry. Okay? When you get a copy of the summons and complaint, if they're served with that, you get that to HELPS. We're going to contact the attorney that sued you. We're going to let them know that your income is protected. You're not going to go to court, and you don't need to go to court. We're going to call you, tell you why you don't need to worry and why you're going to be okay. Okay? Just to hear you say, you don't have to worry, immediately took so much stress off of me. You and your group are a godsend. I will be contacting you after this live. Yeah, I do say that a lot, and I mean it when I say it. And I think I have the experience and the authority to say it. I'm 74 years old. I've been an attorney since 1978, filed tens of thousands of bankruptcy, and started HELPS back in 2012. And we have, thousands of clients of HELPS that we help. So when I tell people they don't have to worry, I mean it. Okay? Elma asks, Eric, should we accept service from a sheriff or others of a debt lawsuit? Well, yeah, if they knock on the door and they hand you the paperwork, you can take it. You're going to get us a copy. We don't need the whole thing, usually the first 3 or 4 pages. You don't need to worry about it. It calls to mind, a client called us and says, well, Eric, I live on a private driveway and I have a gate. And they call me and say, I need to come out the gate to pick up these papers. And I told her, no, you don't need to do that. You don't need to make it easy on them. Okay? You don't have to go out and walk to the end of your driveway to accept the paperwork. But if they happen to get up to your front door, sure, you can take it. You don't need to be worried about it. Or you don't have to call them back and make arrangements to pick up the paperwork. See, who serves you it's either going to be a civil deputy, a sheriff. In most counties in the United States, there'll be a civil deputy. It'll be a sheriff that is assigned to serve legal papers on people. That's one of the things he does. He might do repossessions and things like that. He does civil work. He's not a criminal attorney. And he serves papers, so you don't have to go out of your way to let him serve you. The other person to serve you could be a private party, and they get paid a fee when they get you served. Okay? But it doesn't hurt to be served. Just get us a copy of the paperwork. You don't have to avoid it. This person says, I'm doing bankruptcy. I'm afraid they are going to put a lien on my house. My husband and I are both at hospice and trying to do a trust, and now I'm extremely confused on what to do. I'm in California. I'm sorry. You can call us on the phone. One of our attorneys is located in California, but I can tell you right now, you have a homestead exemption in California of between $600,000 and $700,000 equity in your home, which means if someone were to sue you and get a judgment, you could still sell that home and you could pocket that $600,000 to $700,000. If you've homesteaded the home, which you probably have, or you could still do it in California, then that lien doesn't attach. You could still sell the home. Hopefully an attorney that files bankruptcy would tell you about your protected income. Now, especially if you're on hospice, there may be no need for you to do that. We can go over that with you. You're both on hospice. I'm trying to do a trust now. The only issue could be this. If you owe a lot of money and there's judgments, and you want the equity in the home to go to your children, then if you file bankruptcy, you can wipe out the debt. The judgment goes away, and there's no judgment lien. And then at your death, the property automatically goes to your kids. So there could be a reason to file bankruptcy. You can always call and talk to us. We'll go over it with you. My bankruptcy is $1,900. I'm paying $100 a month. So are you paying in order to file the bankruptcy? You may want to call and talk to one of the attorneys that helps, and we'll go over this with you. Okay. Next person contacts us from North Carolina. Okay. No, it's not. I got bounced around here on my little thing here. They have an RV they can't afford anymore due to her husband's health and other medical issues. This is notes from one of our paralegals. We discussed the protections of their income, that they had no need to worry, and how they could surrender the RV. This was back in November 25th from Florida. They called us again back on December 3rd. Can the RV company put a lien on their home? We talked about their Florida homestead exemption, how the home is protected. No one can take the home. Can we help with the surrender directly? No, we just explain how it's done. If you have an RV that's going back, start making the payment. When they call you about the missed payment, then you can tell them you can't afford it anymore. That's the point, to tell them to pick up the RV. You know, if you don't drive it anymore, you could take the insurance off. They'll get a notice of insurance cancellation. They might pick up the RV quicker. Okay? And they said, well, once the RV has been taken, they'll call back to enroll. And they called us again on December 23rd. We told them again what to do. And they said the loan company requested a handwritten letter stating why it was being repossessed. You don't have to do that. Just stop making payments. But anyway, she said she did that, included the contact info for her husband's doctors. Okay. The doctor said that they would be happy to explain the situation if the loan company called. The loan company contacted her today and told her they would come pick up the RV in 2 weeks. They will auction it off and says they'll put a lien on their home. Well, they can't take their home. There's no issue there. They're just trying to scare her. Well, there's a note here. It says, very sweet couple. Then they called, looks like they called yesterday. The RV was repossessed. It was sold, and they got a letter notice of deficiency. And they didn't want to pay them anymore, and they had other bills, and so they enrolled with HELPS. Okay, that's what we do. We just got a couple minutes here. It kind of flew. Let's see. I want to know if getting served by the courts, do the courts know that the debt collector has been sent a cease and desist letter from HELPS? No, the court doesn't even care about that. And do they have to tell the courts that they have a... No, they don't. A cease and desist letter doesn't prevent them from suing you. It just prevents them from calling you on the phone. They could still take legal procedures. They can still sue. Okay? Kathy says, until I started watching these videos, I thought I was the only one who could not pay their bills after retirement. We don't think as we get older things happen. No, you're not the only one. No, that's why we started HELP, so that you would know you got plenty of company. You don't need to feel bad. You didn't do this on purpose. Life just happened. Well, okay. So it looks like we've come to an hour. Thanks for all your questions today. I hopefully answered them. If we haven't, or you have more questions, you can call us on the phone. We've got plenty of people to answer your calls, although we are busy. I will say that. We did have a video with senior living that went viral 2 or 3 weeks ago, and we've been swamped ever since then, and we're trying to get more help. HELPS is going to be really big someday because there's a lot of seniors need this help, and there's no one else that I'm aware of doing what we do, and that's helping seniors, protecting them from collectors harassing them. So we always ask that you share what HELPS does with others. If you called and we haven't called you back, call again. You can always listen to these videos. We don't want you to worry, and call anytime. Press the like button, and if you haven't subscribed to our channel, do that. Have a great day, and I will be talking to you tomorrow. Have a happy April.